structured way other than how I've set it out in my slides. This is an opportunity to discuss things in a very open way, and there's no need for anybody to feel in any way spooked about having an opinion which might not be based upon how the law currently is or how the law might be in the future. I think I certainly see this consultation as something which is open to comment from any angle and from any perspective in terms of the experiences that you've had. Certainly as a lawyer, I have my own views about how I think the law should be and how lawyers have to play a part in that, but I also have a view as somebody who's involved in mental capacity law in terms of how all of us should have a role in that and how we should be joined up in the way in which we deal with problems as they're faced. I haven't strayed too much into the law here, I say that. I've spelled out in the slides like some quite chunky bits of the Mental Capacity Act, forgive me. I've done that not because I intend to go through it all in any great detail, but because these slides can obviously be circulated and used as a resource in terms of like the base information that we're working from in terms of where the law stands now and where it is the Commission is suggesting, and it is only a suggestion as to where the law might go in terms of changes. So, what I've tried to do is first of all set out what we're dealing with now. And the reason why I've done that is because any of you have had a chance to have a look at even the summary document of the consultation, which if you haven't, I would recommend you do. It's an excellent short summary of what it is that the consultation as a whole says. And I've actually done I put the reference up there for you, and it appears in the flyer that came out in terms of access to the summary document on the internet. The consultation makes very plain that we're not doing away with the Mental Capacity Act at all. Well, whatever changes, and there will undoubtedly be changes, and quite significant changes of that, will still be rooted in the Mental Capacity Act, which is a huge and very important piece of legislation. Those of you who don't know, and forgive me if you do, the Mental Capacity Act was introduced as a means of providing key protections for people who lack mental capacity in terms of how they're dealt with, how they are able to express wishes and feelings, and how decisions are made which have a huge impact upon their lives, not just in terms of depriving them of their liberty, but also in terms of accessing appropriate care, support, and living as full a life as they can in the community. What the Act aimed to do, in a slightly patricial way, was to impose a structure on the decision-making in relation to the person who lacks mental capacity, which for the purpose of the Act and the guidance is someone who's referred to as P. And forgive me for using P, it's a little impersonal, but it helps us in terms of being able to have a base for the narrative that appears in the legislation and the guidance. So I've just highlighted here some of the sort of key principles or key workings of how the Act operates in practice. It applies to people who are 16 years or older, and there is nothing in the consultation to suggest that that's going to change. There is the presumption of capacity. Now that's a hugely important part of the Act, and it's a part of the Act which will not disappear in my view, precisely because none of us should necessarily presume to know what it is that somebody is or isn't able to decide for themselves. And the Act and the guidance that goes with it and the proposals in the consultation document don't seek to change that, because to do so would take away quite a fundamental part of how decision making progresses in terms of someone who has difficulty making decisions or who may lack the mental capacity as the Act defines it to make those decisions. So we work on the basis that everybody, no matter what their disabilities, difficulties are, has the ability to make decisions for themselves until such time as we have definitive evidence that they don't. And at that point, there are certain ways in which we go about making decisions in their best interests. And so again, I think it's really important just to remember that the fundamental principles of the Act, the sections that we'll see in these slides here, I don't think there's anything to suggest that they will change significantly or at all. And that's a very important point, I think, because when we're talking about this concept of protective care or supportive care, it's all very laudable, in my view, and it's all geared towards the idea of greater accessibility and understanding and doing away with some of the bureaucracy that goes with the current system, but it doesn't seek to change the fundamental foundation of how mental capacity law operates. So again, I don't propose to go through that in a great deal of detail, save for the two penultimate points there, the principle of best interest, which we'll explore a little in a minute, and the principle of the least restrictive option. Two extremely important principles which play a huge part, quite rightly, in the deprivation of liberty process that we have at present, and will play a perhaps even more significant role in the deprivation of liberty process that the Commission is likely to recommend. So again, just for your benefit at a later date, and forgive me if you already know this, I know many of you will, but Section 2 of the Act sets out specifically how we tackle the issue of mental capacity. Many of you will know that there is a two-stage test to mental capacity, set out partly there in terms of how we deal with somebody who may lack mental capacity, bearing in mind that we've got the presumption that they have mental capacity. We have to first establish, if needs be with reference to specific medical evidence, that they have an impairment or disturbance in the functioning of the mind or brain. And if we don't establish that, then we have failed the first part of any test, trying to establish whether somebody has or has not got mental capacity. One or two of the points made in the Act itself in terms of like the assumptions or the workings that we might operate in terms of how we think as parents, carers, lawyers, etc., somebody is or isn't able to make a decision, which feeds into any discussion about mental capacity, but shouldn't be the guide as to whether they do or don't have capacity. And why? Because we have a presumption that everybody does have capacity until such time as it's proven otherwise. We go on to the second mental capacity test in terms of somebody's ability to make a decision for themselves. And bear in mind here that sort of any number of people who have various disabilities, be they physical or mental health difficulties, may have difficulty making decisions, but with assistance in the right environment, with a structure around them which enables them to be informed, might very well be able to make decisions despite those difficulties. So again, we mustn't presume that they can't. However, we must pay heed to what the Act actually says in terms of how we go about determining whether they do or don't have capacity, on the basis of understanding the information, retaining the information, and being able to balance it and make an informed decision. It could be an unwise decision. We all make unwise decisions, whether we've got capacity or not, but it's a decision which has to be based on their understanding of and ability to understand the implications of the decision that's being taken. So again, I don't see any of this significantly changing. So when we're talking about, let's say, what the consultation is after, yes, of course, we can comment upon the impact of the Mental Capacity Act, and we can comment upon the concept of best interests and how decisions are made in a practical way on the ground, and the involvement of those who love and care for people who might lack mental capacity. And we may have some very significant criticisms of how that's actually operated on the ground in practical ways. But I don't see, and I'm interested to see what you all think, I don't see that the basic principles of mental capacity and how we assess it, and the basic principles of best interest, which we'll see in a moment, changing significantly. Section 4 of the Act deals with best interests, and again, I don't propose to go through that in any great detail. It's there in the slide. You'll be able to see it for yourselves if you haven't seen it already. But basically, it sort of promotes a number of what are on the face of it and in reality, like very common sense principles, that we mustn't rush to presume what's in someone's best interests. We mustn't rush to presume what someone's capacity is by virtue of how they appear and the decision making, unwise or otherwise, that they have or are making. It's all a question of gathering together all the relevant evidence in terms of what it is that we're looking to do, make an informed decision about their best interest based upon their circumstances, based upon the information that's relevant to their circumstances, their goodwill, their well-being, and what it is that they would want for themselves by way of the wishes and feelings they're able to express for themselves. So again, simply by virtue of the way they present in terms of any difficulties communicating their disability and so on and so forth, that isn't to be something which overrides any other issue in relation to how we determine best interests. And there is a code of practice, as you know, that goes with the Mental Capacity Act, which should inform all of us in terms of how we communicate with those decision makers who have a role in relation to the Act, and how we should be engaged with and informed of any fundamental decision making in relation to both capacity and in relation to best interest. Now, if that's not working, and I'm sure some of you have many different experiences of it not working, I certainly do, then how can we sort of make sure that it does work in terms of starting afresh? Not that necessarily that's what we're going to do, but if we're going to make significant changes to the current system, and we're hoping to whittle down a good deal of the confusing bureaucracy, whilst retaining the key premises of the law, how are we going to make that communication, decision-making process better when we're looking to the principles of best interest and capacity? Now I say that's my view of how it is I imagine Commission is going to want to see things in terms of recommendations, in terms of changing the law, and that's why it's hugely important, and the point Lawrence made I think is perhaps a right one, hugely important, that it's not a consultation, it's not information gathered in the consultation process which is dominated by lawyers. Lawyers have an awful lot to say about this structure. We're like anybody else, sort of confused, annoyed, frustrated by what is a very bureaucratic system. But we only see second-hand the information that there is out there, and there's lots of it, about how things break down in terms of communication. And I say that on a no-fault basis. It's a confusing system. Local authorities have struggled with it for good reason, because there's a lot there to get your head round. But if we're going to change it, make it better, how can we make it better in practical ways in terms of the kind of discussions that we're going to continue to have in terms of what's the right care, what's the right environment, what's the least restrictive option for somebody's well-being, and what is in their best interests. So again, just very briefly, we have various sections of the Mental Capacity Act which deal with where matters go ultimately in terms of any disputes which we're not able to deal with on the ground. And that's in relation to the powers of the Court of Protection. Many of you will have come across the Court of Protection. It's the court that deals specifically with issues arising under the Mental Capacity Act. Here we're dealing with welfare issues, as we call them, but the court also has the power to deal with the financial and property and affairs issues that arise in relation to someone who lacks mental capacity. And the court essentially has a very wide-ranging power to make its own declarations in instances of disputes about what's in someone's best interest, or whether they lack capacity, or what conditions should be imposed upon them, whether they should be deprived of their liberty, etc. Has the power to make those declarations when disputes can't be resolved. And again, I don't see the court's power necessarily changing in terms of being able to make those declarations, save for one significant point, and it's something which, again, some of you, or many of you, might have a view upon, certainly the lawyers will, whether it should remain something which rests with the Court of Protection in terms of making those decisions, because one of the ideas, and it is no more than that, that's being floated by the consultation document, is whether the Court of Protection should retain the ability to deal with welfare disputes, or whether it should be sent over to a tribunal system, a little bit like the mental health tribunal system we have at present. Now again, lawyers have a great deal to say about that. They might have a vested interest in saying a great deal about that, but that's not what today is about. Today is about your perspective in terms of how you think that might be better or not. And if anybody's got any queries about that in particular, not that you would, I'm quite happy to to deal with that when we're having a wee chat. So the court has significant powers. Obviously, you don't need me to tell you that you go to court as a last resort. Frankly, you go and see a lawyer as a last resort. You want to be able to resolve things in a very practical way on the ground, and you should have the wherewithal to be able to do that. You should have the ability to contribute to discussions, to decision making, but I think it's not an exaggeration to say that on many an occasion that simply doesn't happen. There is a communication breakdown, there is a lack of information sharing, there is a lack of engagement in the decision making process. Well, if that's to be improved, so that lawyers are not consulted and you don't have to go to court or the tribunal, and that's all for the good, because ultimately we're acting on the basis of P and what's in his or her best interests, and we're also looking as part of this process of consultation to see whether there is a need for greater bolstering of P's role in any of these issues. Because again, I think it's perhaps fair to say that on occasion P has been sidelined very often in terms of the discussions that go on about what's in their best interests. So again, the consultation document refers throughout, if you've read it or read the summary, to what it is you think, what the public thinks in terms of being able to improve a process at which P will be centre in terms of the decisions that are ultimately taken. Again, very briefly, and I put this up specifically because, again, I don't necessarily see the structure that is in place under the Mental Capacity Act for the court being able to deal with deprivation of liberty necessarily changing significantly. I think deprivation of liberty as a concept and the concept of protective care in its various versions will undoubtedly change, but there's going to have to be a process by which ultimately you're able to resolve disputes about that issue, whether it's protective care, supportive care, deprivation of liberty, ancillary issues to do with best interests, issues to do with contact, so on and so forth. And so I think this is the provision that we have in place at present, Section 21A of the Act, and Schedule A1 of the Act, again, in themselves very confusing, as are the regulations, the guidance that goes with it in terms of how things are actually dealt with practically. But again, I think something like this, perhaps slightly more simplified and structured in terms of a process, is going to remain. What will change is what it is that happens on the ground, and then there's going to be a step on in terms of how it's dealt with if it can't be resolved. So again, I think it's important to remember that we're going to have a legal structure. We have to have the law. Within that legal structure, we're going to have a process of discussion, decision making. We're also going to have a process of challenge, review, appeal, and we're therefore going to have a process of assessment, a tribunal court, which basically enables P or somebody who's concerned for their welfare to raise issues which you can't resolve, and the court tribunal makes a decision about that. Schedule A1, the authorization for deprivation of liberty. Again, just a very quick reminder, because this is what we have at present. As you will know, we have a system whereby somebody can be deprived of their liberty. They can be deprived of their liberty by way of lawful authority via what we call the Deprivation of Liberty Safeguarding Authorization Process, or DoLS. Many of you will come across DoLS, and it's like a slightly cumbersome bureaucratic form, a whole series of forms which seeks to tackle the various qualifying requirements to establish whether it's in somebody's best interests to be deprived of their liberty, and if so, why, and if so, is that in accordance with what we call the least restrictive option, i.e. we should be looking to deprive someone of their liberty to the smallest amount that's necessary to protect their health and well-being, and if so, what the conditions are to be attached to any kind of authorization that's in place. Now, we have that authorization process because we have the European Convention on Human Rights. Now, the European Convention of Human Rights, introduced shortly after the Second World War, has a series of articles, some of them very complicated, but we have Article 5 of the European Convention on Human Rights, which we within the UK legal system have always signed up to. We've been a signatory to the convention since its inception, and since the Human Rights Act in 1998, it has formed a key part of our law in terms of us as people who are subject to law being able to bring that to the court in terms of human rights arguments. We have Article 5 of the European Convention, which isn't going anywhere despite the government's proposals to do away with the Human Rights Act. Article 5 will remain, and I think it's highly unlikely that we won't be at the very least a signatory to the convention still. So we're going to have a system which deals with someone's right to say, I should not be deprived of my liberty, because Article 5 prohibits unlawful deprivation of liberty. And by that we mean there has to be a lawful process which authorises somebody's deprivation of liberty. So, for example, if you go through the criminal justice system and you're sentenced to a term of imprisonment, that's lawful authorisation of deprivation of your liberty, because you've gone through the criminal justice system, the law has decided that it's in the public's best interest and appropriate to sentence you to a term of imprisonment. We'll place that scenario into a scenario where somebody lacks the mental capacity to make decisions about where they should live, who they should have contact with, whether they should be restricted in terms of their access to the community, and doesn't have the ability therefore to consent to being deprived of their liberty. And you have to have a system which enables them therefore to be lawfully deprived of their liberty. Doesn't mean to say that deprivation of liberty is necessarily the emotive issue it is sometimes seen as. The very words deprivation of liberty are in themselves like sort of hugely powerful words. And I think one of the drivers of what it is the Commission is proposing is to get rid of deprivation of liberty, insofar as we're able to do so, and replace it with slightly softer, more caring is the wrong word, but let's a little more accessible wording, so that we're not dealing with something which necessarily creates a difficulty in terms of communication, or a boundary in terms of there being some suggestion of inappropriate conduct in terms of depriving somebody of their liberty. You cannot lawfully deprive anybody of their liberty unless it's in their best interests. And how do you determine best interests? It's via the structure of decision making in terms of best interests, which ultimately goes to the Court of Protection for a declaration if you can't reach agreement about that. And so that's why I say best interest, I think, is here to stay. I think some system of authorization, some system of review, appeal, and ultimately some system of adjudication by the Court of Protection or the Tribunal will remain. But if there's anything wrong with that system at present, and in my humble opinion there is plenty wrong with the system at present, then let's change it so that it's better for everybody. It's better for the person who may or does lack mental capacity, it's better for the people who love and care for them, it's better for the decision makers, it's better for the lawyers and the courts. So everybody understands how it works and how we can put it into practice. And again, I've just listed there the qualifying requirements in terms of the deprivation of the authorisation process at present, which I don't propose to go through. And obviously that's just a brief summary of what it is that the court has by way of a role in terms of deprivation of liberty as it stands. I think there is one important point to raise in relation to that. I've noted at the very bottom there. Articles 5 and 8 of the European Convention on Human Rights. From my perspective and the work that I do, human rights is hugely important in terms of being a thread that runs through sound decision-making process in relation to anybody whether they lack capacity or not, in terms of living the life that they should be living, if they have disabilities or vulnerabilities that they've got to deal with. And so I readily refer to Article 5 if necessary, in terms of somebody who may lack mental capacity, and I readily refer to Article 8, which is the right to respect for privacy and family life. And again, the Commission refers to these two articles as being quite key to the way in which we should be thinking about that sort of changes to deprivation of liberty, because
have the number of those articles again, please?
Article 5 and 8.
5 and 8, thank you.
Because the Commission makes plain in its introductory sections and throughout that human rights and the Mental Capacity Act, whether or not there are going to be changes to the Act, will remain the foundation of how it is deprivation of liberty will be seen in the future. So again, bear it in mind in terms of that sort of promotion of those, because I think it's hugely important if we're looking at doing right by somebody who's got difficulty making decisions and may lack mental capacity to make decisions, that when we're considering what we do in terms of decisions about them, that we always consider, amongst many other things, their dignity, what's right for them, the fact that they should be deprived of their liberty as a last resort and in the least restrictive way, and that we should consider what it is that they should be having in terms of right to respect for privacy and family life. So I've just briefly set out there again what I think are some of the key chapters of the Code of Practice. Again, forgive me if you know all about these. Excuse me, the Code of Practice is a hugely helpful document. There's large parts of it which are written in a very accessible way, which might actually inform the way in which the law will change in the future in relation to deprivation of liberty. I don't know if anybody's come across the Care Act or the Children and Families Act recently, in the Code of Practice that goes with each of those. But they make interesting reading in terms of their accessibility, the way in which they're written in a way which is a lot less legal, if I can put it in that way, than perhaps things like that have been written in the future. And again, one of the things I'd like to see is a continuation of that kind of document, because the more understandable something is, the more everybody can engage in any kind of decision-making process, whether you're a lawyer, a parent carer, or whether you're the person who is being subject to any kind of decisions about you. So again, one of the things which I will certainly be saying in my firm's response to the consultation is the wording, the way in which things are written, the examples that are given, the good examples set by the Code of Practice, not only in terms of this Code of Practice, but recent sort of trends in relation to them. So, with that foundation, the Commission is looking for comments upon their outline proposals for change. Now, the proposed changes are simply that. It's a little bit like a decision-making process whereby they've thought long and hard about the criticisms levelled at the deprivation of liberty process, whether it's safeguarding, whether it's by court authorization, or whether it's in terms of best interest and capacity, and is suggesting changes which the Commission believes, after lengthy consideration and a degree of consultation and gathering of information, largely it has to be said from people who are lawyers or linked to lawyers or who are policy makers changes, but has put forward the proposals it has on the basis that it wants to change the deprivation of liberty process into something which is first and foremost understandable, secondly something significantly less bureaucratic than it currently is, and thirdly not only changes the wording but changes the thinking of how we deal with deprivation of liberty in terms of what it actually means. And personally, I think what they're proposing, give or take some large or small changes, is pretty practical. And I think some of what they're suggesting is something which I think will probably achieve the aims of making it more understandable and accessible. But I'm intrigued to know what you think. I'm intrigued to know what many other people think, because obviously I'm looking at it from the perspective of a lawyer first and foremost, in terms of how that will work in practical terms, in terms of how we interpret something. Because obviously wording is always open to lots of different kinds of interpretation. But the more straightforward, the more accessible, the more practical we make it, and it has to be said, the simpler and more straightforward we make it, whilst at the same time recognising that we've got to be very careful to protect the interests of the person who may or does lack mental capacity, and we've always got to look out for their best interests. I think that can only be a good thing. So very briefly, the consultation is proposing an entirely new system under the banner of the umbrella term protective care, which is effectively the term which will define how the system as a whole works. So you can see it as like sort of a top tier wording. Protective care would come at the top of that, underpinned by principles of protective care, and then drop downs, as it were, in terms of lots of different types of protective care, some of which quite specifically aim to replace the deprivation of liberty safeguarding authorization process, what we call DoLS. Others seeking to change the way in which vulnerable people and or people who may or people who do lack mental capacity are cared for, which is a very interesting part of it, because a great deal of the work that I do would fit into what we call community care law as opposed to mental capacity law. Now obviously there's like huge overlaps between those two areas of law, but community care is ostensibly like sort of seeking and securing a level of care and support for somebody in the community which enables them to live a full and fulfilling life. And now that's whether they lack capacity or not. That's on the basis of their care needs, that's on the basis of their vulnerabilities and disabilities. But what part of the consultation aims to do is to provide a more structured and supportive, protected environment for some people who are by definition vulnerable by virtue of their disabilities, communication difficulties, physical difficulties, and or lack of capacity to be able to make decisions in relation to care as well as in relation to, in relation to issues about deprivation of liberty. And so there are care issues here, there are structural issues in terms of the responsibilities of local authorities and how local authorities carry out their duties to assess, plan and provide appropriate services for people, which come under the umbrella of protective care, according to what the Commission is proposing. And again, that's quite an interesting point, and you may have some views about that, whether there should be a distinction between somebody's care needs and issues to do with their mental capacity, or whether it's something which should be joined up. And I raise that specifically at this point, and again, please feel free to grab me over a cup of tea if you want me to talk it through a bit more, because at present, one of the big difficulties we have in terms of being able to tackle issues to do with care, which also have issues to do with mental capacity law, is that we're having to operate on parallel processes. And by that I mean, again, from a lawyer's perspective, but it's interesting from yours too, I should imagine. If we're looking to tackle the local authority because we think they're not providing an appropriate level of care for somebody in the community, then we would ultimately have to tackle that local authority by way of a distinct legal process called judicial review. Very cumbersome, very time-consuming, very old-school legal process, which frankly is not the most ideal legal process. What we wouldn't necessarily be able to do in relation to what we see as a flawed care decision is bring that challenge to that decision before the Court of Protection if we were dealing with a capacity issue. So I'll give you a very quick example. Forgive me for straying into this, but I do think it's important because it is a fundamental part of what the Commission is proposing. If we were before the Court of Protection arguing about whether it was in somebody's best interest to reside in the community or in residential care, we wouldn't necessarily be able to tackle that best interest issue if the local authority had already made a decision in terms of funding not to fund a community placement because it was cheaper to put somebody in residential care. We would have to go away and challenge that decision by way of judicial review proceedings and keep on a hold the Court of Protection proceedings. Now, without going into that in any more detail, because it's very confusing, what the Commission's proposal perhaps, and I put it no stronger than that, suggests is that we have a slightly more joined up process in relation to that. Care and best interests should in some shape or form be slightly more fused in terms of how decisions about someone's best interests are made. Now, again, the Commission is just putting that out there for consideration, and I suspect that many a person will have some objections to that because it will create its own inherent difficulties in terms of decision making where funding is a part and parcel of it. But again, from the perspective that you might have, certainly in terms of the examples that I can name, that is very often a very big issue because funding at the moment, budget cuts and austerity, is very much top of the agenda of many a local authority. So again, just in terms of the processes that the Commission might need to know about. So we have the principles of protective care, then we have supportive care, restrictive care and treatment, protective care in hospital settings, and palliative care. Now, those are going to be the three touchstones of how protective care will work in specific settings. As I say, some directly to replace DoLS, Deprivation of Liberty Safeguarding Authorization process, others to replace the situation where somebody is in the current situation of any kind of care environment where they lack mental capacity. And that's a very important point, because as many of you will know, one of the reasons why we have this consultation is because the law on deprivation of liberty was tipped on its head last year by the Supreme Court decision, which opened up the idea that many thousands of people were being deprived of their liberty in circumstances where previously we hadn't appreciated that was the case, because the law was interpreted very differently before the Supreme Court case, which opened up the idea that people were being deprived of their liberty in the legal sense, even though they weren't in a registered care home or weren't in a hospital setting, i.e. anybody in any kind of setting, be it at home, be it in shared accommodation or shared lives accommodation, in a care home or in hospital, who was by definition, the definition given by the Supreme Court in terms of restrictions, continual supervision, etc., being deprived of their liberty, it automatically triggered the Article 5 issue that they must be lawfully deprived of their liberty. And so there wasn't anything that was in place to enable that to happen, because the DoLS process relates solely to people in care homes and in hospital settings. So what the Commission's proposals definitely seek to do is to deal with everybody, whoever they are, wherever they are in certain settings, being deprived of their liberty, and how you deal with that, but deal with it in a proactive, deal with it in an informed, a less bureaucratic and more straightforward and accessible way. This is my summary of what the principles of protective care are going to be: an outcome-driven approach, the idea that we're looking for some specific outcome which is driven by P's own wishes and feelings, or is it? Is it driven by like sort of broader, like sort of more benign principles of best interest? Does it follow the current best interest process in terms of like gathering of information, or is it something which should be driven by a slightly more structured decision-making process in which P does or doesn't have a role? That's not what the Commission is suggesting, but I've certainly heard that many people are saying that we should have a system which seeks to make decisions with limited involvement of P. Well, if the Mental Capacity Act is going to remain firm in terms of like, sort of their role central to decision-making, then that won't happen. And as I've noted there, like, so the Commission has made plain that it doesn't seek to sort of stray too far from the current Mental Capacity Act. This is all going to be a system which is broadly going to be based upon the Mental Capacity Act as it currently stands. It's looking to introduce an accessible and understandable system. It's going to remain compatible with human rights, and as I've mentioned, that's chiefly Articles 5 and 8 of the Convention, as currently enforceable under the Human Rights Act, which, again, from my perspective for sure, maybe not from yours, but raises a significant query about the government's drive to do away with the Human Rights Act. What's the point of saying it's going to be compatible with human rights if the Human Rights Act is no longer going to exist, even though the European Convention continues to exist? And it's going to be a flexible and tailored scheme in the sense that it's going to be driven by the particular person that you're making a decision about. Again, you might think that's common sense, but reiterating that is something which is to be, in my view, applauded, because again it goes along the lines of accessibility, understanding, and understanding who it is that we're making a decision about. So, yes, supportive care. Again, many of you will know this, and we'll obviously discuss it in some more detail, but it's designed for people living in a care home, supported living, shared lives accommodation, or if a move to such accommodation is being considered. What this does is it triggers the duty of the local authority to assess, plan and facilitate appropriate care services. And this is what I was talking to you about before in terms of like community care law and mental capacity law. Because I've noted there the relevance of the Care Act 2014 and NHS healthcare, care planning safeguards, public law and mental capacity act overlap, clarity as to tendencies. The reason I've sort of bullet pointed in that way is because I can certainly see some potential difficulties here. I have no difficulty at all with the local authority having greater duties to safeguard someone in a supportive care environment, i.e. when they're going through the process of assessing or reassessing someone's care needs and looking to put in place a care plan or a direct payment and individual budget which seeks to place them or make a decision that it's in their best interest for them to live in one of those environments. I have no difficulty with the local authority doing so within a more structured safeguarding process. Why? Because the Care Act 2014 introduces statutory duties to consider safeguarding, to consider risk, and also, alongside the Mental Capacity Act, the duties lie with everybody involved in that person P's well-being, whether it's in relation to where they live, who they have contact with, or a deprivation of the liberty, to act in their best interests. I'm just curious to know how you join up the two in terms of like having duties which are enforceable under the Care Act by way of judicial review, and duties which ostensibly, in terms of best interest, will be enforceable ultimately in the Court of Protection or the tribunal if it replaces it. But that's effectively what the Commission is suggesting, a more structured, identifiable duty on the part of the local authority in terms of supportive care. To be very welcome in terms of reiterating their duties, linking it to somebody who lacks capacity. Well, that currently happens. Putting it under the banner of supportive care, so there's no misunderstanding about when somebody is likely to be deprived of their liberty or is going to be, or is deprived of their liberty in any of those environments, all perfectly sensible. How do you therefore enforce any of those duties, and what arena do you go to? Perhaps that's a question to be answered by lawyers, but again, I would welcome anybody's views about it. Restrictive care and treatment. This is the direct replacement of DoLS, Deprivation, Liberty, Safeguarding, Authorization process. And again, it's based on a safeguarding model. So safeguarding, in whatever guise it is all geared towards the idea of protection of vulnerable people. However which way you look at it in terms of how safeguarding has been dealt with or promoted in the past, you certainly have guidance in the Code of Practice that goes alongside the Care Act 2014 to some very specific examples of how safeguarding is triggered, how safeguarding is dealt with. And again, I personally welcome the idea of bolstering safeguarding in terms of how we make decisions about somebody. But again, what we're looking at is someone who is currently subject to a DoLS. So it's somebody basically who would satisfy those qualifying requirements. Continuous or complete supervision and control, that's the Supreme Court case which has introduced this as a concept. Person's not free to leave, not allowed in a company to leave premises or unable to leave due to physical impairment. The use of barriers to movement, control of a person's actions including restraint, care and treatment to which the person objects, care and treatment to which a person objects, spelling, significant restrictions upon person's diet, clothing, content. You could perhaps see this as the sharp end of deprivation of liberty, people who are profoundly disabled, who by definition on the medical evidence quite clearly lack the capacity to make decisions in relation to their residence, care, best interests, etc., and who require a significant amount of intervention. You could see this as the sharp end in terms of people who've got profound mental health problems with significant behavioural difficulties and do require a high level of care and support, 2-to-1 care, sometimes restraint to enable them to stop them from harming themselves. And again, if you're talking about somebody like that, you've always got to make decisions, even though common sense might tell you on occasion that you're doing something which is sensible and ultimately in their best interests, whether that's at home or in a shared living environment. But you have to do so within sort of a structured, lawful way, which is currently DoLS, the cumbersome bureaucratic process, which is it's suggested should be under the restrictive care and treatment regime. So a direct replacement of DoLS, envisaging the sort of continuation of that high level of intervention in terms of people who are profoundly disabled. That's how I read it. And again, I'd welcome people's views in terms of whether that's going to be something appropriate. I don't see it can be anything other than appropriate in some shape or form, because we have to have lawful authorization, and we do have to tackle those tricky issues about how we prevent someone from harming themselves, which sometimes involves quite significant restrictions and restraint upon them. Tricky and difficult issues, highly emotive issues, but again, from your perspective, if that's something which you've experienced, then this is your opportunity to shout out about what it is that's gone wrong. And very often that can be decisions being taken which you have no involvement in, decisions being taken which are very restrictive and don't amount to the least restrictive option, and so on and so on and so on. And I've just noted at the very bottom there, the role of the approved mental capacity profession with oversight. This is something which the Commission is proposing in terms of who is responsible for the decisions in relation to these sharp-end decisions that are to be taken, which will significantly restrict someone, will certainly deprive them of their liberty. And it's suggesting that there be a brand new role of the approved mental capacity professional who has oversight of the decisions, the authorization for, the review of, and ultimately therefore has a significant duty of care to ensure the well-being of the person in that scenario. Again, it's a different version of the DoLS system, which, as we saw with the principles, is geared towards the idea of accessibility, understanding, lack of bureaucracy. But these are hugely important issues. We are depriving someone of their liberty. If someone objects to that, whether that's the person being deprived of their liberty or someone who lives and cares for them, how do we go about making sure that we have a voice in terms of, let's say, the decision itself, and any potential challenge. And then we have protecting care in a hospital setting and or palliative care. This is a separate system to the two that we've just seen. This is a system which is geared towards the idea of how you specifically provide care and support in those settings, which obviously are quite specific. What we've been dealing with previously was deprivation of liberty in any setting, in terms of the definition of deprivation of liberty as it applies in a domestic setting, for example, shared lives, shared accommodation, etc. But it's recognised by the Commission that there are going to have to be specific scenarios where someone is in hospital or in palliative care and may require detention in some shape or form, whether they actively object to it or not, and therefore a deprivation of their liberty. And what they're suggesting is that this be dealt with in the way that's set out there. What we're talking about is someone, again, who lacks mental capacity to consent to treatment, consent to being in a place, but where a decision has been made that it's in their best interest for that to happen for a period of 28 days, a little bit like mirroring the process at present that's under the Mental Health Act for people who have severe and enduring mental illness, but not following that necessarily. We're not necessarily dealing with someone who's got a mental health problem which requires detention under the Mental Health Act. What we're dealing with is someone who still requires some form of hospital or palliative care, but who may object to that or who might not be able to consent to it. And the 28-day period, I guess, is being suggested by the Commission because that's the period that is currently in place in the Mental Health Act, so there's certain logic to it. And within that 28-day period, a decision has to be made as to whether that continues in terms of hospital care and or whether you're considering something more restrictive, which is what we were talking about before in terms of restrictive care. And one aspect of the Commission's proposals, which I've put together all in one here, is the importance of independent advocacy. Now again, many of you will have come across advocates working under the auspices of the Mental Capacity Act specifically, but advocates working in terms of decision making and assisted decision making for people who may like or do like mental capacity. There have been great strides in advocacy in terms of its importance, certainly under the CARE Act 2014. And we currently have a system, as many of you will know, under the Mental Capacity Act, where we have a statutory role for an independent mental capacity advocate. Now, I don't think anybody could complain about advocacy being a central part of the process of decision making in relation to care and support and in relation to decisions under the Mental Capacity Act. And again, what the Commission is suggesting is that the advocacy role, again, is front and centre alongside safeguarding in terms of how those decisions are taken for someone who does or may lack mental capacity. And is reiterating the importance of advocacy in terms of informed decision making, advocacy being important in terms of gathering information, advocacy being important in being able to get the views of P, if at all possible, P's wishes and feelings, and make sure that P's position is protected. So again, I don't think there's any sort of controversy in relation to the role of the advocate in the Mental Capacity Act, but again, that's my perspective. So if advocacy is something which has been something which creates divisions in terms of decision making, and it's easy to envisage where it can possibly, and is something which is again yet another barrier to communication, or is something which is not allowing an open debate or discussion about best interests, then again this is the opportunity to raise that. I'd be interested to see whether everybody does think that, because again, in my humble opinion that the contrary is the case. And again, just very briefly, the Commission is suggesting the possibility of a formal right of appeal. Now again, my reading of what it's suggesting is the possibility of matters being dealt with by a tribunal process rather than it going to the Court of Protection. A tribunal process which is a little bit like, possibly a mixture of the tribunal process as it currently exists in terms of welfare benefits and any number of different chambers of the current tribunal system. Or something akin to the Mental Health Tribunal, which isn't actually called the Mental Health Tribunal now, but it's a chamber of, I think it's a social, forgive me, but it's within the tribunal system, which, just in very simple terms, is a slightly, how shall I put it, slightly more accessible, less stuffy, less high court orientated system, still run by judges and judges' clerks, still very much populated by lawyers, but again a more straightforward, more accessible legal process. So again, if anybody's got any thoughts about that, the Commission's all ears. Lawyers have got an awful lot of thoughts about that. Personally, I don't necessarily see any difficulty with the tribunal system, but for the fact that the Court of Protection has in recent years gathered a fair bit of expertise in terms of the Mental Capacity Act, and has got to a point where I think it's probably safe to say that the judges sitting in the Court of Protection are now very switched on to the broader issues under the Mental Capacity Act in a way which you wouldn't want to lose that by transferring it to a tribunal system and starting from scratch. And also, it's something I only very briefly touch upon in the slides, and I haven't gone into any great detail about, but the Commission does talk about what it calls the Mental Capacity Act, Mental Health Act interface. What it effectively means by that is that there are any number of scenarios where somebody lacks mental capacity to make decisions, but also has a significant mental health problem, which on occasion requires their detention in hospital for assessment and treatment under the Mental Health Act. And there are lots of overlaps in relation to those two pieces of legislation. Generally speaking, the Mental Health Act takes priority over the Mental Capacity Act, but again, it's asking the question, do we want to regulate in a slightly more structured and understandable way that is the case? Should that continue to be the case? And one of the issues that forms part of that interface is whether, by transferring over to a tribunal system, we're going to get confused about mental capacity and mental health law. And I think there's probably some strength in that suggestion. Very briefly, I'm reiterating at the very bottom there the importance of best interest in the person's wishes and feelings, the question of priority. I mentioned it before, very briefly. The Commission is just raising in a general sense the idea that sort of wishes and feelings is all well and good, but should we be operating a slightly more structured, perhaps you might view it as slightly more ruthless process of best interest decision making, which aims to get to a decision quicker and more effectively, with perhaps less consideration of someone's wishes and feelings. In a situation where, this might sound the wrong way of putting it, forgive me, in a situation where somebody's wishes and feelings and back history and difficulties and so on and so forth might not be the way forward in terms of what is right for them. Now that isn't what best interest is currently all about necessarily. Wishes and feelings play a huge part in the best interest process, but again, the Commission's floating that in terms of whether there should be priorities in relation to them. And again, just very briefly, there is the suggestion of a formal legal process for supported decision making. Supported decision making, as you'll know, is something very different to the idea of assessing what's in someone's best interests, which is a process of information gathering to make an informed, cooperative decision about what's in someone's best interests. Supported decision making is a slightly more complicated, structured system of enabling someone to make their decision on the basis that it will be recorded as something which will then be definitive as to what it is that they have decided to do. So again, that's a very different notion to best interest, and perhaps feeds into the idea of best interest, person's wishes and feelings and priorities. So again, it's floated out there for comment. Just very briefly, summary. It closed on the 2nd of November. I've put down there the sort of the internet access to the summary document, which if you haven't read it, it's great. It's really easily understandable. The Commission is suggesting that we need a clearer, more accessible and understandable system. It's aiming to reduce bureaucracy, clarity as to the nature of care, settings and how a person is deprived of their liberty, a structure for assistance, support, advocacy and appeal, continued compliance with Mental Capacity Act and human rights, and a clear legal structure. That's how I read what it is that the Commission is seeking to do, all of which I think are perfectly laudable, perfectly achievable. It's just how the nuts and bolts of that work in terms of what they're proposing in terms of protective care as a whole and its various versions. But I hope that helps. I have hurtled through it a fair bit, but it's not all about me, it's all about the chat that we're going to have now. I think after today, if anybody's got any queries which I can help with, heavens, I'm always happy to try and provide any answers that I might have, not that I do. So you mustn't hesitate to have a chat to me today. I'm probably clocking up about like 1:30, but that's plenty of time to have a chat, so hope that helps.